Today we're examining two sovereign citizen cases, beginning with an update from Kansas. Abel Estrada was recently found guilty of driving with fake license plates that he had purchased from another sovereign citizen scammer. Following his conviction, he is now attempting to have Kansas taxpayers cover the cost of his appeal, a request that is unlikely to succeed.
We are on the record in the 13th Judicial District Court of Greenwood County, Kansas. This matter comes on for review in 2024 TR 617, State of Kansas versus Abel Estrada Jr. Paul E. Dean appearing for the state, Mr. Abel Estrada Jr. appearing in person and pro se via Zoom. Now, Mr. Estrada, you were convicted of displaying an illegal license plate. You apparently had a legal plate in your car, but you chose to put on your car a plate that you had ordered specially made from a company, and I can't remember at this point what it said. You didn't like the decision, and
Your Honor, this is the exhibit.
There it is. Thank you. And that was manufactured at your request by a private vendor. And you were found guilty, and you said you were going to appeal. I don't believe you have paid. I don't believe you've posted your appeal bond. Then you filed some motions for today, but the main concern is you need to either pay or appeal, perfect the appeal. And if you don't, I'm going to have to direct the clerk to send in the notice to the state to suspend your license for non-payment. So let's take a look at the file. Okay, I do see something dated 2/19/2025. Notice of appeal to appellate court, and you filed that notice of appeal. So you started the appeal process, but typically they don't accept those until or unless accompanied by an appeal bond. And you did not pay that cash bond, did you?
No, I didn't. I actually did the papers, and I got a letter from the appellate court, and they said that I needed to be signed. I sent it in, but it needed to be signed, so I submitted it. As soon as I got it, I submitted it to your office, and then they told me at your office that you wanted to see me today here about that letter. All I need is to get a signature. I perfected all the paperwork. For some reason, it didn't go, but if I get the signature, then I'm continuing. I'm doing everything that's supposed to.
It seems unreasonable for someone who openly rejects U.S. laws to expect taxpayers to finance his appeal if he was able to spend money on fake license plates. He should also be able to provide the funds for his own bond.
Well, I see you filed one page. It says motion to proceed in form of papyrus. I, Abel Estrada Jr., is disabled and am requesting for a waiver of court fees for the appellate court. Sincerely, Abel Estrada Jr., and it's signed and dated 2/28/25. Well, apparently, Mr. Dean, that's up to the district court to make that determination on an appeal. I would have thought the appellate court would have made that.
That would be my understanding as well. I don't know what letter Mr. Estrada is speaking of. We don't have anything. I don't have anything that shows. I've got the notice of appeal. Mr. Estrada has not been sending copies as would be required to opposing counsel of his filings with the Court of Appeals. We've received nothing. Mr. Estrada, in criminal cases, civil cases, whatever kind of case you're involved in, when you have another side to the case, which is always the case, if you file something, you're supposed to be providing copies to the other side so we know what you're doing. Just as we file a notice or something of that nature, we have to send you a copy. If we file a motion or something else, or they did the initial complaint, you get a copy of it. etc. So I don't know what he's speaking about. I just know that we've had judgment for some time on this case. And let me see.
If I may,
Well, I show the journal entry of trial. Let me see if it was filed February 21st. And that shows that he was found guilty of displaying unlawful tag. He was
I think he's still within his 60-day docketing time period. So
I think so too. So, Mr. Estrada, what is it you want to say?
here's the letter that the appellate court sent me saying that I just needed the, sorry, this one. I just needed the signature on the papyrus, form of papyrus. I don't know if you can see it.
no, we can't. Why don't you read it to us, Mr. Estrada?
Oh, I don't have my glasses. Well, can you read it for me? I have my wife because I don't have my glasses. Yeah.
Mr. Estrada, the office received on April 2, 25, your certified envelope postmark.
Ma'am, hold on a second. Sorry, could you come more in front of the screen because we're getting a really I'm at least getting a muffled sound. I can't really tell you.
I can't track it. If you get in front of the camera and tell us your name.
Hi, my name is Annie Estrada.
Abel Estrada's wife enters the scene, often referred to as the other half of his last two functioning brain cells.
Anna Estrada.
Annie Estrada.
Annie, A-N-N-I-E.
Yes.
Anna Estrada, and you're the wife of Mr. Abel Estrada Jr.?
Yes.
And you have a document in front of you with the Court of Appeals? Okay. If you'll slowly and loudly articulate that, because it is very muffled for some reason.
Did you want me to read the whole document?
Well, just the
personal part.
Okay.
Body of the letter. Where it says, I'm assuming dear Mr. Abel, and then whatever's below that, or dear Mr. Estrada, excuse me.
Yes, the office received, Mr. Estrada, the office received on April 2, 2025, your certified envelope postmarked March 31st, 2025. You enclose the documents which we have reviewed. At this time, you're unable to docket an appeal based upon the following issue. First, we need either the docketing fee of $155 or a file stamp copy of the signed order of indigence by the district court judge. You have enclosed a motion to proceed in form of papyrus, but no order by the court has been provided. Next, we need either a file stamp copy request for transcript document filed with the district court with service on both the court reporters and opposing counsel, or a statement that no transcripts will be requested with service on the opposing counsel. A request for transcripts must note that it is being made for purposes of an appeal and must comply with rules 2.04 and 3.03. Finally, please be advised that docketing must occur within 60 calendar days of the filing of the notice of appeal with the district court. If this does not happen, then it will also be necessary for you to submit a motion to docket appeal out of time to this office, along with the items noted above. This motion must also be served by you opposing counsel.
Yes.
It appears your deadline for timely docketing would be April 21, 2025. As a result, a motion to docket out of time is not currently required, and we cannot hold the motion you have submitted as it does not serve your opposing party. Only the appellate courts of Kansas. The remaining documents you have submitted will be held by your office on your behalf for a period of 6 months pending receipt of the items noted above. This office is unable to provide legal advice or assistance.
The letter essentially confirms that you haven't paid your appeal bond. You haven't served the opposing attorney. The judge hasn't declared you indigent, and yet you're already requesting an extension for a deadline that hasn't even arrived. In short, it's clear you don't know what you're doing.
All right, so you have not perfected your appeal. You've merely filed a notice of intent to appeal. Sounds like that's the only thing you have, and that the Court of Appeals is not officially recognized.
Your Honor, it also sounds like the Court of Appeals gave him a checklist of things he needs to accomplish that we're not authorized to advise him how to complete.
Right.
Which I already did.
Clearly you haven't, sir, because the Court of Appeals just told you the list of things they need you to do, including sending a copy and certifying that you provided me a copy of things that you file with the Court of Appeals. They specifically
Don't interrupt him. Let him finish.
They specifically advised you that you had not. And I have not received anything from you except for this motion to dismiss liability, which, Your Honor, I don't know that I have anything to argue on that other than it's nonsense, and I'd ask you to deny it. I mean, I don't even know what he's attempting to do, whether he's asking the court to reconsider the judgment, doesn't state that, whether he's asking the court to make an indigency finding. He has presented, other than naked statements that he claims he is, has provided nothing to the court to make that consideration, or whether he's asking the court to waive the appeal bond. It doesn't say that either, but those are the three logical conclusions I could come to that he's trying to request. But I don't believe anything's been presented that would give him relief, and that's all I have to say on the topic.
On your motion to dismiss liability, let's take that up. It says, I reserved my right not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly nor voluntarily or intentionally. Furthermore, I do not accept any liability of a compelled benefit of any unrevealed contract of a commercial agreement. And then it's signed Abel Estrada Jr., living man, authorized representative for Abel Estrada, straw man. Now, I'm going to deny that because I share the state's comment or belief that it makes no sense. It doesn't have any legal argument in it. So motion to dismiss liability, whatever in the world that's intended to be, is hereby denied.
But Judge Webster, how could you possibly deny his motion when he managed to use both straw man and living man in the very same sentence?
Journal entry of continuance. Did you file that?
I think the journal entry of continuance, Your Honor, may be the last one where we're reviewing the status of the appeal and or the payment of costs and fines.
That's what that was. Okay.
Yeah, the payment of the appeal bond. So I believe that was a late April date on the perfecting the appeal. So I would ask the court to set this over to someday in early May. It hasn't been properly completed at that point in time. The state would be moving to dismiss the appeal.
If I may, I did submit copies of everything that they asked me to your office. And by the way, the actual April letter that I sent certified, that was the second letter that I sent. I sent it because when we went to court the last time, it didn't seem like you guys got anything, so I resent all the paperwork again for the second time. But all they're asking right now is the papyrus indigence, which you already have, and then the request for the records. I already sent it in, and I sent the COA. So I did the paperwork. It's been sent, and everybody got a copy of it, or at least at the court of record. That's what they told me. They said, do I need to send one directly myself, or do you get a copy? And I told him, Mr. Dean, the judge and Mr. Dean gets a copy, and they say, no, don't worry, they get a copy. So I submitted that to you guys already.
Okay, when you say I submitted to you guys, who do you mean?
I'm sorry?
Who do you mean when you say I submitted it to you guys?
To the court of record.
Who is the court of record? Is that the district court? Is that the court of appeals? Did you send it to the clerk? You sent it to the judge?
I sent it to you directly, magistrate, and I sent it. I put it on the court of record. So they told me there at the court of record that you're gonna get a copy also. That's why I submitted this already.
Filing with the court alone isn't enough. You also have to serve it on all parties involved, including the prosecutor. If you didn't do that, the motion is already invalid. But truthfully, it's written so poorly that it collapses on its own anyway.
I see where I signed off on an order to remove a document from the record that you had apparently misfiled, a motion to docket appeal out of time, and it was premature. You shouldn't have filed that, so that was removed. Missy, didn't you show me that he had brought something into the office, but I'm not seeing it in the file. I don't know what he brought in. Do you have that, or should I have that somewhere? It seems like I saw something that he may have. Missy, are you there?
Yes, I'm here, Judge. I can see there was a paper. Let me go see what it was.
See if it's at the clerk's office. But as far as the informa pauperis, I have not made that determination. I did appoint you, perhaps I shouldn't have, an attorney, since this isn't or wasn't the level of a jail sentence that would have entitled you to the right of an attorney. And you fired that attorney, and then we appointed another one, and you didn't want to use him. But as I recall, you do have a monthly income. And remind me, does your wife work?
No,
Okay, well, I have never seen, I've never made that determination, and I'm not inclined to make it at this time. You do get some income, as I recall, and if you can afford the transcript to be made in this case, I don't know why you couldn't afford to pay the filing fee.
I'm requesting the papers because it'll cover it. And then they told me at the court this morning that when I do the request, that it's not going to be charged to me. I don't have to pay for the request. And all I need is the letter that I submitted, which is, for some reason, they're asking for you to sign. So I submitted it to you as soon as I got it.
Your Honor, I would respectfully request the court the court's denied the motion that was before the court today. Set this matter over to early May. Mr. Estrada wants to argue things, in my opinion, to this court that's claiming conclusory issues that it's been completed, yet the letter that was just read to us specifically contradicted numerous things that he said that he's done and taken care of. I just sent a message to my office to confirm that we've received his copy of this motion to dismiss liability. I'll give you one piece of advice. When you're filing something, what the court said is you need to send notice to me. You put a certification here at the bottom saying, listing everybody, whether it's Greenwood County Attorney, the District Magistrate Judge Webster, and their addresses, and the date you mailed it. That goes here. That's called a certification that you provided notice to the other side so the other side can properly respond. Nothing. I don't even know that you actually know her address in any event. I think Mr. Estrada has a number of issues that he's been specifically told in that letter that needs to be addressed, and he needs to address them in the fashion that he deems appropriate. And we should review it in May.
It's clear from his demeanor that the prosecutor has completely run out of patience with Abel Estrada's nonsense.
All right, Missy, what do we have in May?
We have May 9th. I think that's the only May date we have.
Okay, what time? 11?
11.
All right, I'm going to continue any remaining matters. Well, I'm going to continue the pay or appear to May 11 at 9 a.m. You're either going to have that paid and cover all of those matters that the appellate court has listed, including paying that appeal bond, also known as a supersedious bond. That needs to be paid of $158 cash.
May I ask a question?
Go ahead.
I just need to know if you're going to sign the formal papers letter that I sent you.
I'm not signing that at this time.
That would be holding justice from me.
No, As she explained, indigent status applies only to those who can actually prove they cannot afford the costs, not to someone who simply refuses to pay. Since Estrada likely won't be able to cover his appeal bond, the appeal will be dismissed, which in turn means his license will be suspended for failing to pay his fines. And because he insists he doesn't need a license to drive, it's almost certain he'll find himself right back in court.
People versus Robert Scholl.
Very good, yeah, people.
We're here by special appearance, Your Honor, and remain in honor and not to argue but to challenge authority.
Your name?
Showman Robert Lewis.
This is the date and time set for a preliminary exam. Mr. Chauvin appears here on his own. As we've done in the past, Mr. Chauvin, I need to make sure you understand your rights today with regards to the potential to be represented by counsel. We've had this conversation before, correct?
I do not consent to any statutory authority presumed by this court.
Okay. We've had that conversation before about your right to have an attorney.
I am representing the all caps name, Your Honor. I am the attorney.
No, you can't represent someone unless you have a P number issued by the state of Michigan. And honestly, the longer a sovereign citizen hearing drags on, the more ridiculous it becomes.
Okay. Do you want to have an attorney assigned to you?
No.
All right. You understand that if you wanted to, the court would have the Michigan Indigent Defense Counsel assign you.
I understand that.
Okay. You understand also the challenge of the crime that you're charged with?
Yeah, I don't understand that.
The maximum penalties? It's a felony charge of non-sufficient funds check that occurred on or about May 31st, 2024. Maximum penalty is up to 2 years in prison and a $2,000 fine or 3 times the amount payable, whichever is greater. You've heard all of those maximum penalties before?
I have.
You have any questions about them?
No.
And having heard those maximum penalties, is it your request today to proceed on your own without counsel?
Yes.
Okay. You know that I have to treat you as if you had an attorney, correct?
Yes.
Okay. You know that I can't assist you in any way as we go through this hearing. You're going to have to question witnesses on your own, make the decision on whether or not you want to testify. You understand all that.
I do have the right to question.
You do?
Yes.
Okay, you do. But I won't be able to help you with that.
Right.
You understand that? Okay. Have you ever gone through a court hearing previously where you represented yourself?
No.
Okay. Have you looked into what a preliminary exam entails and exactly how this is going to go procedurally?
You briefly explained it to me last time we were here.
Okay. So do you have any questions right now about the process?
Well, my first question is, my question really regarding the whole thing is, I don't know if she is,
Who's she?
the prosecuting attorney is capable of even speaking in this thing.
I'm not sure if that's what you mean. My question was about preliminary exam. I'll let you can make your motion here in a moment if that's what you're getting at, but do you have any questions about this preliminary exam?
No.
Knowing all that, all the understanding and explanation that I just gave you, your decision today to proceed on your own.
Yes. Yes.
All right. You want to bring up a couple issues?
Yes, I have an issue with the fact that under the bankruptcy of the United States of America, does the prosecutor have bonded fiduciary or sworn trust? Does she act as a prosecutor with bonding and act as a trustee for the United States? So is she able to do that?
Yes, if she's a district attorney, then she was elected to that position and has the authority to hold people accountable.
Are you asking me a question?
Yes.
Okay. I'm not going to answer any questions. You have a motion that you want to make. Are you challenging something? And
Yes,
say
I'd like
that the court should move in one direction or another. I'll make a decision on that.
I would like to make a motion to challenge the validity of the prosecutor being able to prosecute this venue.
Based on what? I'll give you a chance. Based on what?
Based on the bankruptcy of the United States of America.
Okay.
Because is she a trustee for the United States of America? That is my motion.
All right. Ms. Lee?
Thank you, Your Honor. Your Honor, I'm a licensed attorney in the state of Michigan. I am employed by the county of Oakland, and I have authority to exercise my prosecutorial duties within any district court within the county of Oakland. Furthermore, Your Honor, this charge is not anything that has been charged federally. Otherwise, there would be a federal prosecutor here. This is a county level from the city of Berkeley. So yes, I do have authority to move forward with these charges because the charges did come from my office, which is at the state level.
All right, and I reviewed the complaint prior to today's hearing. It complies with the Michigan court rules and statutes that are at issue. Mr. Chauvin, you've made an objection. It's been being recorded on the record. The court's denying your objection, denying your motion. We'll move on to there. You have another motion you want to make? Are we ready to go?
Yes, I also have a motion for denial of process, that this should not even be taking place because I was denied access to documents, records, by making me pay for a fee for copies, which is against the Constitution.
What copies did you have to pay for?
Copy of records,
Which records?
my court filings.
Your court filings?
Yeah, that I submitted.
You needed copies of the documents that you submitted?
Yes, certified copies.
Did you get those?
I had to pay for them.
Okay.
There should be a judicial notice, I guess.
I have something here with me. Did you get anything?
I did not, Your Honor.
Did you want to review this?
May I approach, Your Honor?
Any response to what he's talking about?
Your Honor, I mean, with regard to getting certified copies, everybody has to pay for those, so I'm not entirely sure where the issue lies. Furthermore, they're his documents, so I'm not entirely sure why copies were needed to begin with. So I also have nothing to do with whatever fees are issued by the court.
Sure. So those fees are again set by court rule and statute, and you know your objection to the court imposing those fines, or not fines, but fees to get the copies, those are overruled. The court's just following the court rules with regards to that. Your motion is denied with regards to the impact it may have on your due process. If it did have any impact, it would be a negligible one, given the fact that they were the documents that you had submitted. And the court register of actions would just simply confirm that they were actually submitted, which you could have also done by bringing your own second copy, having a true copy made, or a stamped copy returned to you that way. But in any event, I don't believe it has any impact on the way that we're going to proceed today. So again, you made your motion. There's a record of it. I denied it, and we're going to move on to the next. So do you have any additional motions?
Yes, I have one more motion. I think that this case should be totally thrown out because there was no legitimate warrant, sir.
No legitimate what?
Warrant.
Oh, warrant. Okay.
Which is why we're here in the first place.
No legitimate warrant.
No lawful warrant. I apologize.
Before I let you respond, what are your objections to the warrant that they would make it unlawful?
Well, I wasn't notified of a hearing to have the warrant issued, and under law, Public Act 1957, I'm allowed to be at a hearing where a warrant is issued in my name.
Were you denied access to the hearing?
I've never received a notice.
Okay. All right. Continue.
Your Honor, the warrant was issued by the office. It was sworn to by the court, entered into the system. I believe that there is not only case law, but statute, Michigan law, that allows for that to occur without having the person being charged present.
I agree. I'm going to again deny your motion. You made a record of it though, and that's the court's ruling. So any additional?
No.
All right. Then everyone can have a seat. And did you want to call your anything from you?
Yes, Your Honor. I would just ask for a mutual sequestration. I'm not sure who this individual in the court is.
Okay. Who's in court with you?
This is my wife.
Okay. Is she a potential witness in the case?
Your Honor, is this Kimberly Chauvin?
Yes.
She's listed on here as a witness, so I'd ask that she be sequestered as well.
Okay. Any comments about that request?
She kind of helped me with counsel though, so.
Okay. She can't do that. She's not, is she an attorney?
No.
Okay. So she can't do that. So that's not a basis for me to deny the request. So the reason that we'll have everybody step out on both sides, so that any of your witnesses except for the officer in charge would also need to be out in the hallway, is that all the testimony will then occur and no one will be able to hear it and have that influence the way that they're going to testify. So on that basis, the motion to sequester witnesses is granted. So Ms. Chauvin, you need to step out in the hallway and we'll get you when it's your turn to come to the testimony. Okay? All right. Your first witness.
Thank you, Your Honor. People call Matthew McBride.
Next, the testimony will begin, starting with the bank teller.
All right, so before you get seated, please raise your right hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth. I do. Put your hand down and have a seat. Once you do get seated, if you state your first and last name and provide the spelling of both for the record, please. Sorry. Oh, jeez. Can I break this? Sorry. Well, Tony's.
Sorry. Matthew McBride, MATTHEWMCBRIEN.
Go ahead and say you.
Thank you, Your Honor. Mr. McBride, where are you employed?
Credit Union 1 in Berkeley.
And what is your job?
I'm a teller.
I'm going to draw your attention to May 31st of 2024. Were you working that day?
Yes.
And are you familiar with a Robert Chauvin? Did
Yes.
you see him in the courtroom here today?
Yes.
Can you please point to him and identify something he's wearing?
I guess a pale shirt.
Thank you, Your Honor. Let the record reflect that the witness has identified the defendant. I'm showing you what's been marked as People's Exhibit 1. Please take a look at that. And is that a copy of the check that was provided to you on that date?
Yes.
Did he also provide a copy of his ID?
Yes.
And once he provided copies of the check and his ID, what happened next?
So he did, I handled deposit and then he wanted to do multiple cash withdrawals.
And did you provide the withdrawals to him?
Yes.
And how were they provided to him?
In envelopes, like different denominations.
Okay.
Usually ask for certain amounts in separate envelopes, so.
And it was cash?
Yes.
So the check that was provided to you, what was the amount on that?
It's 30,000.
30,000. Okay. And how many withdrawals were made?
7.
Okay. And what were the amounts of the withdrawals?
So one for $1,024, $960, $1,500, $600, $1,200, and $2,000.
All right, Mr. Chauvin, you have the opportunity to cross-examine this witness. I have no questions. All right.
If you choose not to ask him any questions, the court will simply assume that everything he stated is true. Quite an interesting strategy.
People call Jillian Taylor.
Ms. Taylor, before you get seated, if you'd raise your hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes. Ms. Taylor, where are you employed?
Credit Union 1.
And is that in the city of Berkeley?
I used to be the manager in Berkeley. I'm now at St. Clair Shores, but I was, yes.
Okay. I'm going to draw your attention to September 5th. Did you contact, of 2024, did you contact Berkeley PD?
Yes.
Why did you do that?
Our risk management department sent over a packet to send down to them. So when they knew that, they just send it to the branch manager, we call and hand that over. It was, from my understanding, it was because a bad checks had been passed and was causing us a loss. So they were sending that down.
And the person who had deposited those checks, were they notified to your knowledge?
I believe so, yes.
Okay.
Objection, Your Honor, as hearsay.
Did you provide a packet from your loss prevention to Berkeley PD?
Yes.
So you gathered everything up and gave it to them?
They gathered everything up. So they sent me the packet complete. I don't actually.
So you just, okay.
Yes, I just handed it over.
Okay, thank you. Your name.
All right, Mr. Chauvin.
Your name, nothing further.
Mr. Chauvin, any questions for the detective?
Yes. I'm sorry. On the date we spoke on the phone, did you have any intent, or did you think I had any intent to defraud the bank?
Objection, Your Honor, calls for speculation.
Stand.
All right, I have no more questions.
Ms. Mr. Chauvin, do you have any witnesses you were calling?
I just don't understand. If you weren't planning to cross-examine witnesses or call any of your own, why choose to represent yourself? At the very least, an attorney would have made some effort to help your case.
Will you be testifying? And ask to bind over?
People who provide over in charge of any argument for vote.
Mr. Showman, any comments about bind over?
Yes. So to bind over is to go to circuit court, correct?
Correct.
Okay, so I do have one question though. In my attempt to cure debt, I attempted to deposit a bill of exchange, which is lawful, and they rejected it. So why is that not taken into consideration here?
Because it was rejected. If your so-called bill of exchange isn't recognized as legal tender, then naturally it's going to be dismissed.
Okay, so your argument is that you tried to cure the debt, and so for those reasons, the case should not be bound over.
Yes.
Okay.
Your Honor, I would just indicate for the record, you did testimony that the bill of exchange that was presented by Mr. Chauvin was indicated to be not accepted as tender legally to the bank. Furthermore, Your Honor, that's a question of fact for the trier of fact.
All right. The court's heard the testimony from the witnesses today, the arguments of the parties. I find that the testimony provided by the two witnesses from the bank and the detective do meet the probable cause standard required at the preliminary exam to bind over this matter to the circuit court. Mr. Chauvin brought up a potential trial defense. That's an argument that you could make later on down the line. But as of today, that is a question of fact and whether or not that was an actual legal tender that you had provided. And it's not a basis to deny the bind over. So that's something that we'll continue to move on down the line here. I find that the testimony met the burden. So count one is bound over to circuit court for further proceedings and box.
The audio quality wasn't great, but this was a bind over hearing. A probable cause proceeding to determine whether the case should be sent up to the circuit court.